Please be seated. This is the time scheduled for oral argument in Abramovitz Investment Properties, the Red Eye Jack Sports Bar in Ken Marischal et al. Our case number 1, CACV 120869. Each side has been allocated 20 minutes for oral argument. If the appellants desire additional time for rebuttal, you need to reserve it. There's a clock on the podium. It'll show how much time you have left, including your rebuttal time. So you really have got to manage your own time. To assist you all, you should be aware that we have read the briefs, we've studied the record, we've read the cases, we're familiar with the issues, and we've conferenced the case. Additionally, you should be aware that we are recording this matter, both orally, audio recording and video recording it. So when you step up to the podium, smile, be ready for your close-up, and clearly state who you're representing. One last thing, and that is, even though each side has been allocated 20 minutes for oral argument, although I doubt in this case this will apply, if you don't feel you need all 20 minutes, don't use it. If you're done, you can just sit down. With that, counsel for the appellants.
I'm smiling. Your Honor, Mike Platty, Dickinson Wright, Mariscal Weeks, here on behalf of the appellants, Red Eye Jack Sports Bar, Inc., Jack Ghilardi, and Nevada Land Commercial Real Estate, Inc. Your Honor, there's a judgment. The judgment that was entered in this case against my clients, I'll divide it into two portions. One is the Abramovitz portion of the judgment, and the other I'll call the Marchiol portion of the judgment. I spent a lot of my time talking about the Abramovitz portion of the judgment, and I want to start by highlighting what I think are the legal defects in that portion of the judgment. That was basically a judgment for lost profits damages on contract claims and tort claims. And now I'll subdivide that, talking about the contract portion of the Abramovitz judgment. There are at least two legal defects with that portion of the judgment that I want to highlight right here, and I'll come back to some details later if I have time. The first is that the portion of the judgment that finds Mr. Ghilardi personally liable for breach of contract. He was not, the record is clear, he was not a party to that contract. I think you have to be a party to a contract to be liable for breaching it. And I think we've established that some of the arguments they've raised to try to get around those basic facts and basic legal principles don't work, and that portion of the judgment, I would submit, has to be reversed. And I would just add here that that's an important issue in and of itself. If this court does nothing else in this case, reverse that portion of the judgment, then I think there is a fee award of $500,000 against Mr. Ghilardi personally that at a minimum would have to be reversed as well.
Why would that be the case? There's a fraud claim here. He arguably is an agent of the, well, I think the court basically found that, but he's an agent then of REJ, and he can be personally liable as an agent for the frauds that he's involved in.
That's correct, Your Honor, and I'm going to address those claims.
Okay.
But all I was saying was, as part of the fee claim, the fees that Abramovitz were awarded were based on the breach of contract claims, and if you don't find them personally liable for the breach of contract claims, I think the fee claims attach.
The fee issues are rather complicated here, given the various statutory bases for the fees and also what was and was not raised and briefed. And I don't want to take you off your stride here, but I have some questions about fees, but I'm not sure I'm persuaded that if Mr. Ghilardi, and I guess now it's his estate, correct?
Yes, correct.
On this point, should we modify the caption to show his estate?
I think we could do that if you prefer that.
Okay. Well, if the estate is liable, on the, let me think, if the estate is liable for the frauds, then that's another issue as to the fees, but go on.
As to Abramovitz, I
Right.
think that's correct.
Yeah.
Okay. And then broadly, the second defect on those contract claims, and this goes to both the corporation, or I'll call it REJ, and Mr. Ghilardi, is that lost profits damages are not a proper measure of damages for a breach of contract in this particular kind of case. I think we've cited the general law that when you have a contract for the sale of real estate and the seller is unable to convey because it lacks title, the measure of damages is not lost profits. And I think we've cited the authority for that. At most, I think what you would have is a damage formula that talks about the market value of the property minus the contract price.
But there are many cases in which a person buys what they think is going to be income-producing property, and the only value to them is its income-producing potential. And depending on whether the potential use of the property was in the contemplation of the parties, wouldn't lost profits be a form of consequential damages?
Consequential damages, no, because what you have here, the market value, what the authorities talk about is the market value of the property captures that income-producing potential that you're talking about in a more, what we call less speculative way. And that's what the case authorities talk about, is like, this is the proper measure of damages. How are they damaged on this day? What is that market value minus the contract price?
Well, let's assume for the moment that's correct. There's no evidence in this case about that.
And that is our point. Your
Well,
Honor.
but the plaintiffs here, the Abramovitz group, put on evidence of a damage theory through their expert. And if you didn't, or your client didn't think that was an appropriate damage theory or had some problems, you needed to cross-examine, present evidence to the contrary. And I don't see anything in the record in which the REJ defendants did that.
Well, we did not have a contrary expert.
That's right,
true.
yeah.
And we did cross-examine, and we thought we established that the damages were speculative but through cross-examination, but the trial judge didn't agree.
Mm-hmm.
But the proper measure of damages is a legal issue for the court. The courts decide what the proper measure of damages on any particular type of claim should be, and that's a pure legal issue before the court. And if the proper measure of damages, which we contend should not have been lost profits, then there is no evidence of that, and there would need to be a reversal here.
Can I backstep a second?
You bet.
You were arguing about, I may have misheard you, about the award of attorney's fees against Mr. Ghilardi
Correct.
to the Abramovitzes?
Correct. What I was referencing before was the Abramovitz's award of attorney's fees against Mr. Ghilardi personally.
Right. Where's that in your opening brief?
Well, all I was pointing out was that if there is a reversal on the breach of contract claim, okay, if there's a reversal on the breach of contract claim, that matters, and that's one of the ramifications that would.
But shouldn't you have argued that in your opening brief, that if you reverse the breach of contract claim, you've got to reverse an award of damages to to the Abramovitzes?
I don't think that would be necessary. I think that would be the result of your rulings, because at that point, you've got their claim. When we go back and talk about a vacation of the judgment, if that was going to happen, the claim that for their attorney's fees was based on 12-341-01 contract. And if you vacated that portion of the judgment, then it would follow. I think that's just a ramification, one of the many ramifications that I would say. And if there's a reversal here, there's many potential areas where parts of the judgment could be upheld and parts of the judgment wouldn't be.
So you're saying you didn't have to argue it?
That's what I am saying, Your Honor, yes.
Okay.
Yes. Now, moving on to the tort misrepresentation part of the judgment in favor of the Abramovitzes, what we basically have here is a misrepresentation case for benefit of the bargain damages. And we've cited to you law on two specific points that creates a defect in this judgment. The law is fairly clear that when you're talking about benefit of the bargain damages, those are available only when the bargain has been consummated. And I think that's comports with common sense, but the authorities we cited are fairly clear on that. And the evidence is undisputed here that this bargain was not consummated. They had a contract that was in escrow and never completed, and therefore you don't get benefit of the bargain damages on a bargain that wasn't completed.
So I can go out and tell someone, I'm going to sell you X, or offer to sell something. They can think they're going to buy it, and then I can say, sorry, Charlie, I don't really have ownership of this item or this property, and you can't get lost profits, even though I knew that you were going to use that property for income-producing potential?
I think that's correct, Your Honor. And the part of
Strike you a little odd that I can go out there and defraud people with impunity and not be responsible for that?
I'm not saying with impunity.
Okay.
I am not saying with impunity. I think in those kind of instances, you could have a causation of damages or out-of-pocket expenses. If you have expenses, you relied on the representations, you relied on the fact that you thought this was going to be a sale and there were expenses, that would be appropriate, but that's not the damage theory they asserted here. That would make them whole.
They sort of lost profits.
But
Right.
that would lead you to the benefit of the bargain. And again, I've found no case that talks about how you get common law benefit of the bargain damages in a bargain that was not consummated. There's no cases out there, and I don't think that's an accident of that. And we've cited some authorities that actually say, look, you got to consummate the bargain. Once you've got the bargain completed.
I think the case you cited involves a legal malpractice claim rising out of a failure to convey mineral rights. And there, the lawyer who gave an improper or negligent opinion on an abstract of title, no matter what he did, he couldn't convey property. A, he didn't own the property, and B, it had nothing to do, the mineral rights had been conveyed by the owner years and years earlier, so his negligence had nothing to do with the ability to consummate the conveyance of the mineral rights. That's completely different than what we have here.
And actually, Your Honor, what that case was cited for was the proposition for causation.
That's true, yeah.
Okay, there was some case, an Illinois case, Gold versus Dubish, which we cited to, that was exactly on point. It was a sale of a business, and what you had was the business was not, the bargain was not consummated, so you don't get benefit of the bargain damages. That case is precisely on point, and we cited several other cases in other jurisdictions that agree with that. And again, I haven't found any case that's to the contrary of that. Now, a second point is also that we have, Arizona has provided a formula, okay, and they basically says, look, when you get benefit of the bargain damages, you have a formula where we're talking what the value of the property is if it's true as represented, what that would be, minus what the actual value of the property is. That's benefit of the bargain damages. And again, I didn't tell the plaintiffs to go assert this theory, lost profits, benefit of the bargain. This was their theory, but they went about it the wrong way. You can't get lost profits for benefit of the bargain damages under Arizona law. It would be creating new precedent if you did, and there's pretty good reason not to do that for the reasons we cited in our brief.
Well, your argument is the benefit of the bargain is limited to the difference in the value of the property and what he paid for it.
Correct.
Right.
Correct.
And not lost profits.
Correct.
So it's just two different, but you're just saying what is the best benefit of the bargain? They're saying it's lost profits. You're saying it's limited to the difference in value.
That's correct. That's
Is that a
correct.
fair summary? Okay.
That's a fair summary. And then finally, what I would call, I guess, the alternative or supplemental argument we've got on this is that even if there was a conclusion that that lost profits were an appropriate measure of damages, I mean, the lost profits that were awarded in this case were unbelievably speculative. And I understand trial judges have deference in making factual findings, and I understand that you accord that, but you still review for clear error and whether there's any substantive evidence. And my opposing counsel is going to get up here and say, well, there was an expert and he gave an opinion and that's evidence. Well, I would submit, Your Honors, that if you have an expert that's testifying in a speculative manner, that speculation is entitled to zero evidentiary weight here. And here what you had was an expert, an economist, doing a model forecast, and he was forecasting rental profits 10 years into the future. And if you look at his $2.9 million conclusion, the first 9 years he forecast, in present value terms, $600,000 of profits through his analysis. And then in the 10th year, his estimate, he's estimating 10 years out, that there would be $400,000 in profits, and you turn that into a terminal value of $2.1 million. I can't think of anything much more speculative than that. Whether coming from an expert's mouth, still speculation, and shouldn't be entitled to any evidentiary weight, and you can alternatively reverse on all the tort claims and contract claims on that basis. And then what I want to do is move quickly.
Let me ask you a question. If we were to agree with you on on some of your arguments on damages and reversed, what do? We remand for a new trial on damages?
Yeah.
Careful what you ask for.
Yeah, and I understand that, Your
Yeah.
Honor. I understand that, Your Honor. And I think Your Honors would have discretion. Okay, Your Honors would have discretion to say, okay, we're going to redo this again, and here's the proper theory, see what you can do. I also think you'd have discretion to say, hey, look, you guys are the ones, Abramovitz, you put all your eggs in the wrong basket on lost profits, and you can reverse and end this. But I think you have discretion on that, and we'll take our chances on a remand. Really quickly, because I want to reserve some time for rebuttal, I just want to address the Marchial claims. The Marchial claims involve a fee award, and we're talking statutory interpretation. There's two statutes that they rely on for their fee award, and we think that in doing a de novo review of the statutes, you'll find that neither of them apply. The first one is 33-411, and I just want to read that statute. I was frankly unfamiliar with this statute before I started handling this appeal, but it does say, any document evidencing the transfer of real estate shall be recorded by the transferor within 60 days of the transfer. In lieu thereof, the transferor shall indemnify the transferee in any action in which the transferee's interest in such property is at issue. So 2 quick points. Mr. Ghilardi was held personally liable under this statute, and that is improper. He was not the deed transferor. The deed transferor was Red Eye Jack, the corporation. So that alone, I think Mr. Ghilardi shouldn't be liable under this statute. And number 2, the statute really doesn't make sense to apply it here. The evidence in this case is that the deed was signed and was sent to the Marchiols. They had the deed for 4 years. Apparently they couldn't record it at first. Then they got a lawyer 4 years later and got it recorded. The legislature could not have intended the statute to apply in that situation. So I would submit 33-411 isn't the proper basis for attorney's fees. Their other basis is 12-341-01. The case law is clear. When you have a quiet title case, the quiet title statute trumps any kind of breach of contract. There may be contracts involved, but the quiet title statute trumps. And they've admitted themselves 12-1103 isn't the basis for
But
fees
did you
here.
preserve that argument? We've looked at, given the competing arguments on waiver, I believe that REJ argued there needed to be allocation or apportionment between the quiet title claims, and you cited, I believe your colleague cited the quiet title statute, but I don't see anywhere where you said they don't get any fees under 12-341-01 because they have not shown that they complied with the tender requirements of the quiet title fee provision.
Well, and the reason that isn't in there, because in their fee application, if you read their fee application, they never even contended that as a basis. They never even contended 12-1103 as a basis. And we mentioned that in our response, and then we
I
say.
know. They may not have asked for it, but you have the burden to object. That then would have allowed them to, if they in fact did a tender, to show that they had complied. But there's no objection, you're not raising the argument. It's not joined before this trial judge.
Oh, no, Your Honor, I would disagree with that. When you go, I'm sorry.
Go ahead.
When you go back and you read what we wrote, we said, well, look, they never raised this 12-1103 as their basis for attorney's fees. And what we said is, hey, look, now what we have here is a situation where they've got to apportion. There's clearly fees that were related to quiet title, and they can't get fees related to that. We said that. It's clear in our brief that we said that.
So you're saying that you actually did raise the issue because you said, insofar as you're seeking quiet title, you can't get fees because of 12-1103.
Absolutely. And then they didn't try to apportion, so now we're up here, and
Where did you say that?
we said that in our response to the application for attorney's fees. And we cited that in our response brief, and If I can preserve 2 minutes for rebuttal, I will look at the exact site and get that for you.
Okay, thank you.
Good morning, Your Honors. Louis Lopez on behalf of Abramovitz Investment Properties and Moiseller Hendricks. Just by way of roadmap, I want to dial in and drill down the two issues that the appellants raised regarding the method of damages that were calculated, and then also Mr. Ghilardi's personal liability. This argument regarding benefit of the bargain damages, Your Honor, is really been a little bit of a moving target. When you look at the opening brief, they argue that when you do a benefit of the bargain analysis, you can't somehow encompass lost profits. And we cited to Your Honor the Texas Supreme Court case in Formosa, the only state that has specifically addressed that argument. And the Texas Supreme Court said absolutely not, that benefit of the bargain damages can include lost profits so long as you establish them with a reasonable degree of certainty, which is what Judge Willett did in this case. Now they've kind of shifted the paradigm in the reply brief to argue, well, what Formosa is saying is really benefit of the damages is this market price, contract price differential. And they cite cases to argue that that is the way in which you calculate benefit of the bargain damages. The problem with that, Your Honor, is that argument is not even consistent with Arizona law. When you look at our Raji Standard Contract Instruction number 20, when you're dealing with a breach of a land sale contract, it allows the jury to award damages for the difference between the sales price and the fair market value of the real estate at the time of the breach, and there's an and any consequential damages suffered by the plaintiff. So even in our revised jury instructions, when we're dealing with a land sale contract, it contemplates that you're not limited by this market contract price differential. And then when you take the next step and you actually look at the comment when it talks about consequential damages, it cites to McAllister v. Citibank, which is the very case that we cited in our response brief in which the court held consequential damages include lost profits. So if you want to go down this market contract price differential, that is not even consistent with our own instructions that we give to the jury. But what's really happening on top of that is that the appellants truly don't understand the analysis that Mr. Duncan did in this case. We calculated that and we labeled his calculation as lost profits. When you look at Trial Exhibit 61 and you look at page 6 of his report, what he specifically does is he recognized, like Your Honors did, that this is an income-generating property. The Abramovitz bought this property because they own 3 additional buildings in the area. This was the perfect synergy for that business. They had a history in that they owned the building that Cooperstown was there. They had been in business for 10 plus years. They knew how to do it. Mark Abramovitz had kept his eye on this property for many, many years because of that synergy, and they were looking for that income generation. And that's why Mr. Duncan concluded that the best approach in terms of doing his damages is to use the income approach. That is a standard appraisal approach that any appraisers do when they determine the market value of the property. And in fact, when you look at Mr. Winius's report, which is Trial Exhibit 132 and page 59 of his appraisal, he identifies the income approach as an appropriate method in determining the property's value. So then look at Appendix D, and you see the analysis that Mr. Duncan did in this case. He determined the net operating income. He looked at the likely rental rates that were going to be generated from that property. He deducted expenses, leasing commissions, and other property expenses. And then he also, Your Honors, deducted the $1.13 million, which is footnote 24 and notations in that appendix, to reflect the principal loan balance that the Abramovitz were going to have to get in order to complete this transaction. And he deducted that. He came up with a number and using discounted cash flow analysis and said, this is the damage that my client suffered. Now, we labeled that as lost profits. Whether or not you call it lost profits, whether or not you call it a market/contract differential, whether or not you call it consequential damages, the bottom line is the way in which Mr. Duncan did his damage analysis is the same exact way that the appellants are arguing he should have. They are just getting hung up on this notion of lost profits, and they're trying to attach a different label to it. Don't get misled by it. Don't be led down that road, because it doesn't apply. Because when you actually drill down in the analysis, you see he did exactly what he did. But on top of that, what they continue to ignore is that when you look at both contract damages, when you look at tort damages, in addition to benefit of the bargain damages, we are entitled to recover consequential damages. They have never argued that we're not entitled to consequential damages. And if you look at page 18 of Judge Willett's findings of fact, what did she rule? She ruled that the plaintiffs were entitled to consequential damages as a result of the defendant's actions in this case. So what are the consequential damages? They're lost profits. Whether or not you want to call it, how you want to calculate it, and what label you want to attach to it, the bottom line is they are consequential damages. So it's pick your poison. Which one do you want to do? Do you want to argue this contract market analysis, which Mr. Duncan did, or do you want to say these are consequential damages? The end result is the same. Judge Willett did not err in awarding the consequential damages in this case.
She just classified it as lost rental profits.
Correct.
She didn't say these are consequential
Well,
damages.
if you-
Oh, yeah, yes, she did.
Page 18.
Entitled to consequential damages. You're
Yes.
right. Okay. As a
Page
result of this
18,
action. You got it.
absolutely.
Okay.
So she did do this. So why they're getting up here and arguing about this issue, Your Honors, respectfully, just doesn't make any sense because they don't understand what's going on. This notion that we're somehow precluded from recovering benefit of the bargain or consequential damages because the real estate transaction was not consummated, it's absurd. That result rewards the tortfeasor and punishes the innocent party.
But technically, the benefit, I mean, as I read the briefs, the benefit of the bargain, there are two different theories of what the benefit of the bargain is. I mean, one theory is it includes lost profits, consequential damage. The other is, no, it's limited to your difference in value and what you paid for it.
Well, the Sanderson case that the appellant's relying on, Your Honor, it deals with the sale of a car. It doesn't deal with real estate property, and it doesn't deal with an item that's intended to generate revenue. And that is a factual distinction that the appellants don't recognize or argue in that particular case.
I understand that, but I'm just saying, rather than deal with labels, the benefit of the bargain can be either A, in some cases, consequential damages, or B, in other cases, just the difference in value.
Absolutely, 100%.
Okay.
You are absolutely correct. And the three cases that they've cited, they're all non-Arizona cases, they're all non-Nevada cases. None of them deal with real estate transaction. One is an IPO stock issue, one of which is a company was obligated to stock mini fridges in a hotel. Another one was a sale of business. None of it was a sale of real estate in which the buyers intended to use it, and the appellants knew that the buyer intended to use it for income generation process. Let's not lose sight here that Mr. Ghilardi knew exactly what my client's business was. It's the reason why Mr. Warigi recommended that Abramovitz Investments purchase the property, because they knew exactly what my clients did. It's why he recommended to Mr. Ghilardi that he sign off on the sale with respect to that. The evidence in terms of supporting that calculation was absolutely there. Both experts testify that that property was going to be leased up within 12 months. Mr. Duncan used the same type of secondary sources of materials, COSPATs and other real estate, in order to evaluate what the market rates were going out there. My clients had a history of operating in that particular area, so he had the ability of the Abramovitz and their history in terms of that aspect of it. And more significantly, the appellants didn't present any expert testimony ever questioning the sufficiency of the evidence or questioning the methodology. Judge Willett had no choice but to find that the damage calculation was reasonable certain, and she found that the Abramovitz testimony and their history in operating the area and their explanation as how they were generating profits was credible. And that's clearly within her province and her preview to do so. So to suggest somehow that there wasn't sufficient evidence, Your Honor, it's just not, it's not correct. Aside from that issue, I want to talk about Mr. Ghilardi's personal liability and a contract claim, okay? Because again, that has been a little bit of a moving target as well. They're now taking the position in the reply brief that Red Eye Jack ratified Mr. Ghilardi's actions. Take a step back and think about that. What Red Eye Jack is now saying is that we ratified Mr. Ghilardi's fraud committed against the Abramovics. When Mr. Ghilardi lied to the Abramovics about owning the property, about Red Eye Jack owning the property, they ratified that, and they were all okay with Mr. Ghilardi doing that. When Judge Willett found that Mr. Ghilardi used this transaction as nothing more than a sham deal to try and leverage a buyout against the Marchiols and MLP, Red Eye Jack is now saying, oh no, we signed off on that. We ratified that. That's an absurd result, Your Honor. That is an absurd result for Red Eye Jack to somehow suggest that they ratified the fraudulent acts of their purported agent.
I'm sorry, and I thought you were going to be talking about Mr.
Ghilardi.
Ghilardi's liability for breach of contract.
Correct.
I misunderstood. So you're talking about the fraud, and that's where you lost me, because you jumped from, okay, now they're saying they ratified, the REJ ratified the alleged, the fraud, but where do we get that? How does that relate to the breach of contract, Mr. Ghilardi's liability, personal liability for breach of contract?
Absolutely. 14.1 and 14.3 of the contract specifically include representations that Red Eye Jack owned the property and Red Eye Jack would take no action that otherwise deprived the Abramovics' ability to do that. Mr. Ghilardi violated that. He lied regarding...
But Mr. Ghilardi didn't sign the agreement.
Mr. Ghilardi did sign the contract, but in his individual capacity, not on behalf of Red Eye Jack. His signature appears at the bottom of that contract. He does not identify himself as acting as an agent for Red Eye Jack. He does not identify himself as an officer of the company because he was an officer of the company.
I thought he was not an officer.
He was not. He was not an officer, shareholder, or an agent in any ways.
But the contract on its first page says it's between REJ, the corporate name, and your client. And it has to be signed by someone, and it's quite clear who the parties are to it.
Well, that raises an interesting question because it wasn't clear who the parties were.
Well, it certainly was in the face of that contract. I don't see, honestly, I don't see how you can argue to the contrary. I really don't.
Well, aside from the contract, take a half step and look at the finding of fact that Judge Willett made in April of 2008. Because in April of 2008, Judge Willett found that Mr. Ghilardi personally, through Nevada Land Company, Mr. Warigi, committed to remove the 2004 warranty deed.
Yeah.
That was an individual promise by him to us, supported by consideration.
But a corporation can only act through people. It can only act through people. Mr. Ghilardi doesn't have to be a corporate officer. He doesn't have to be a president. He can just be an agent. And as the agent for the company, he gave instructions to Nevada Land, and Nevada Land went out and made representations and did various actions. But I'm not persuaded by the argument that Ghilardi entered into this contract on his half when it says over and over again, REJ this and REJ that. I mean, it's just not persuasive here.
Well, because I think what you need to do, and I think what Judge Willett did a very good job of segregating the time period, because there's the initial liability for signing the written contract itself, and then there's the representation in April 2008.
There's no question that an agent can be liable for frauds made on behalf of a principal.
Absolutely.
That's a whole nother kettle of fish over here. But we're talking about breach of contract over here. And here, the agent, Ghilardi, was acting for a disclosed principal, REJ. And so your clients distance themselves from any alter ego or piercing the corporate veil claim. So that's all they've got on the contract claim.
Well, respectfully, Mr. Ghilardi was not acting on behalf of a disclosed principal. Mr. Ghilardi was purporting to act on behalf of MFLP and Mark Yule.
Excuse me, just because he in his mind may have thought he had some type of agreement with MFLP, nevertheless, vis-a-vis your client, through the broker, he was acting on behalf of REG. Just because he had something in the back of his mind as to these people doesn't mean he wasn't acting that way. And so, again, I'm just not persuaded by this.
I agree with you that on the written terms of the contract, that it appeared that we were dealing with REJ. I don't disagree with that proposition.
Okay.
I do respectfully disagree with you that there was evidence presented at trial that Mr. Ghilardi was the agent of REJ. In fact, the evidence presented at trial was that he was not an agent of REJ. In fact, the appellant presented no evidence at trial regarding agency at all. The only individual that had the authority on REJ to testify that Mr. Ghilardi was their agent and that they were ratifying Mr. Ghilardi's act was Susan Coe. Ms. Coe was the sole officer shareholder of the company. She never testified at trial. They never presented evidence at trial that Red Eye Jack ratified that actions or that Mr. Ghilardi was ever their agent.
You know, I think you're right in the sense, I don't recall anything from the trial transcript, and Mr. Ghilardi testified, I was the agent for REJ. I don't think he ever made that specific statement. However, everything he said he did, everything that Nevada Land said that he did, painted him in the context and characterized him basically, if I needed to have a bottom line as to what this man was doing in this deal, he was acting for REJ. He was their agent. The fact that he didn't say, I am the agent, doesn't mean that's not what he was doing.
Well, I guess, Your Honor, respectfully, I would have to disagree because Mr. Warigi, who was the broker on the deal, testified that he had no contact with REJ, that he was not transacting any business with REJ, that everything that he was doing and all his marching orders that he was getting was from Mr. Ghilardi. And in fact, Mr. Ghilardi, during his trial testimony, Your Honor, at page 72, lines 2 through 14, testified that he didn't even know whether or not he was authorized to act on behalf of REJ or whether Ms. Coe was authorized to act on behalf of REJ. So while I understand facially what you're saying makes sense, when you drill down the actual evidence that was presented at trial in terms of Judge Willett, she was faced with a situation in which Mr. Ghilardi testified under oath that he didn't know whether or not he had the authority to act on behalf of REJ. She had no testimony from REJ saying Mr. Ghilardi was authorized to take these acts and were ratifying this conduct. You had Mr. Warigi testify that my only contact was Mr. Ghilardi, not Red Eye Jack. And then on top of that, you have the undisputed testimony that it was not an officer shareholder company. And I don't think you can fault Judge Willett for making a decision based upon the evidence that was actually presented at trial because the appellants didn't carry their burden on that issue. And let's not forget, when we talk about the April 8, 2008 transaction, the promise by Mr. Ghilardi, the clear title, even now on appeal, Red Eye Jack has taken the position that they never committed to eliminate that 2004 title issue. They're saying Mr. Warigi never committed to do that on our behalf. Well, you can't argue that we somehow ratified Mr. Ghilardi's actions to immunize him on liability, but then at the same time say, as to this act that Judge Willett found committing this binding contractual commitment between Mr. Ghilardi and Abramovitz, we didn't commit to do it. You can't have it both ways. You got to choose. They chose not to ratify that act. And that's the ratification. That's the act that Judge Willett found at page 8 of her findings of fact that my clients detrimentally relied. She ruled at page 8 of her findings of fact that Mr. Ghilardi, through Nevada Land Company, committed to remove the 2004 warranty deed. And my clients detrimentally relied on that promise and adding the additional $100,000 earnest money deposit and moving forward. That is a contract between us and Mr. Ghilardi. His only affirmative defense with respect to that personal liability was to somehow argue, no, I was actually an agent for this principal, whether it's a disclosed principal or undisclosed principal, and he didn't carry the burden. But the fact that he doesn't carry the burden on that affirmative defense doesn't relieve him of personal liability.
So you're saying the breach of contract is not the breach of the purchase contract, it's the breach of the contract that was made when Mr. Ghilardi through Nevada Land said we'll take care of this this quote forged deed?
Your Honor, I'm greedy and I'm trying to argue both ways. But what I'm saying is
whatever contract you want to
exactly.
This is why this case is a problem.
But
because all of you, frankly, all of you have been inconsistent in the arguments from the beginning to the end, and this is why no wonder trial judges go wild. Honestly.
And I
Let me
agree,
just do this.
and I agree with that. The reason why it's been a little bit of a moving target, Your Honor, is because the facts have been a moving target. Mr. Gallardi on one hand says I own, he doesn't, and it changes.
Where in your opening brief, your answering brief, do you say the contract that was breached was that he was held liable for was the contract, Mr. Gallardi's contract to clear the title?
It is on the argument on the undisclosed principal liability theory, Your Honor, and it is also on the on the causal analysis. We also argue that in those two particular points. And I apologize, that's the one page I don't have off the top of my head. But if you look at that, you will see
Causal argument.
Exactly.
And
on the undisclosed principal liability theory. And it was specifically, I know we're out of time, but it was specifically made in response to the West Virginia case that they argued, because it distinguished in our case, Mr. Gallardi made a specific promise to perform conduct that induced us to take an act, where in the West Virginia case, they didn't promise anything.
And where in the trial court did you make the argument the contract that was breached, not the fraud, the contract that was breached was the contract to clear the title?
Well, I think that's reflected at page 8 in Judge Willett's findings of fact, because Judge Willett found that Mr. Gallardi, through Nevada Land Company, committed to remove that 2004 warranty deed. And then also, if you look at the joint pretrial statement, Your Honor, which I believe is the record of Exhibit 317, page 6, lines 19 through 23. I'm sorry.
Go ahead and say that again.
Page 6, lines 19 through 23. We also identified that we were seeking to hold Mr. Gallardi personally liable for breach of contract and breach of the covenant of good faith and fair dealing.
On that, on the agreement that he would clear the title.
Well, we argued that, Your Honor, if you look at page 3 through 4, I believe on that deals with a specific section regarding the April 2008 email and the commitment that they were going to remove the 2004 warranty deed.
Okay.
Thank you, Your Honor. For those reasons, I request that you affirm the decision.
Use all the time they were reserving.
There's no time left. Do you want to give them a minute?
Well, can you do anything in a minute?
can
I
answer
would
any
be glad to.
questions that you might have.
Well, I actually do have one question, so can we
Go
have a
ahead.
minute?
Sure.
Okay.
I was under the impression that each appellee had
No.
20 minutes.
No.
So
Well, you got to split the time.
I'll have to have a phone call with Louis after that to thank him.
That's okay.
All right.
My name is William
It is a moving
King.
target.
My name is William King, and I'm here on behalf of the appellees Ken Markeel and the Markeel Family Limited Partnership. We submit that there were two bases that the award of fees was correct under 12-34101 and 33-41101.
If, sir, in the interest of time, we've read your briefs on the discussion of 33-411, so could I just shift it to 12-341? And I'm really only interested in discussing whether 12-34101 was preserved vis-a-vis personal liability for a fee judgment by Mr. Gallardi. That's really my focus. And Mr. Your opposing counsel made the point that they really had preserved the issue of that 121103, the quiet title fee statute excludes any fee award under 12-34101. And in looking at this, it's record on appeal, it's index 407, which is their response. If I look at that, they do argue, and I will be candid, I hadn't quite read it this way, that they argue, I believe it's at page 5, that they say MFLP accordingly should have apportioned its fees incurred in relation to the 33-411 claim. And then they go on to line 6 saying MFLP particularly cannot seek any fees for claims related to its claim for quiet title, citing 121103 and the Lewis Pleasant County. So why didn't they preserve that argument?
Well, first of all, I don't think this is a quiet title case.
Well, let's assume we think it is. Then
Okay.
why didn't they preserve the argument?
Your Honor, they didn't preserve the argument because there's nothing in here in this brief that says a 121103 is the exclusive basis for any fee award. They, in fact, segregated their brief
Well,
into three
excuse me,
separate.
line 7 says the exclusive basis for attorney's fees for quiet title action lies in ARS 121103.
Correct, but they're trying to take that a step further now on appeal and say that the quiet title statute not only trumps 12-34101, but it also trumps 33-41101.
Well, let's assume for the moment they only argued that insofar as trumping, if I can turn that into a verb, 12-34101. Where does that leave you vis-a-vis a judgment against Mr. Ghilardi for fees?
I'm sorry, can,
Well, if they preserved the argument that the quiet title statute barred claims for fees under 12-34101, where does that leave your client with respect to the fee award it recovered against Mr. Ghilardi personally?
under the contract statute?
Under the recordings, yes, or under the...
Under the indemnification statute?
Okay, but he's not a transferor. Let's assume we agree with that argument. Where does
Okay.
it leave your client?
Well, if he preserved the argument that 12-1103, well, first of all, if this is a quiet title action,
Right.
and he preserves the argument that 12-1103 is the exclusive basis for the entire fee request
Against Mr. Ghilardi?
against Mr. Ghilardi, and again, assuming that he's not the transferor under the statute,
Right.
it leaves my client without a remedy for a fraud that was committed by Mr. Ghilardi on his own behalf and for an improper purpose.
Well, you've got REJ, don't you? They're the transferor.
We respectfully disagree with that for the reasons set forth in our papers.
Counsel, you're out of time.
Thank you, Your Honor.
And let's say add 2 minutes on to the REG, the appellant's time, if you would. Thank you, counsel.
Your Honor, I'll wait for that. I'm not going to cheat here. Your Honor, a few points I want to raise here. The Abramovitz counsel cites the Formosa case as some kind of authority. Right? Formosa was not a real estate case. It is inapplicable. In that case, the word lost profits, the word profits was used, and we're not talking about ongoing operations from a property. It was basically a contractor's profits on a project. It's completely inapplicable here. I want to kind of ferret out, because the court seems a little bit concerned about this distinction between consequential damages or benefit of the bargain damages. The cases are clear in Arizona where you talk about benefit of the bargain damages or out-of-the-pocket damages. Lost profits are not out-of-pocket damages. They can't be. So on the fraud claims, we're not talking about that. And with respect to the contract claims, the cases are clear. What they're basically saying is the damage that's done in this type of situation where a vendor who doesn't have title, doesn't convey property, you take that market value of the property, subtract the contract price, and you get this base damage. And what the case authority that we cited tells you, when you're talking about profits, you can get profits around the edges, profits that aren't captured in that formula. The Wolyansky case that was cited, if there's a delay in getting title, they eventually, like in this case, if they eventually gotten title, you could capture profits for the period of delay. What the cases also talk about with respect to the failure to convey title, what they say, and this gets a little bit to what you were talking about, Judge, is you have rules in effect where if this property, if it's not captured in market value and it's contemplated by the parties, you can capture those profits. So let me give you an example of how that could have happened here. If, for example, Abramovitz, while they were negotiating this contract, had told REJ, said, hey, look, we're going to have this contract for $1.5 million. I'm going to flip this property right away. Okay, I am going to flip this property. I got a contract buyer for $1.8 million. Flipping houses, reality shows you've got nowadays. Maybe if that was happening here, what you'd have there is a situation where, all right, this 1.8, this extra $300,000, that's something that's not captured in the market value of the property. And it's also something that the parties contemplated. So if there's a breach, you can get those profits. That's what these authorities talk about. Okay, the authorities don't talk about how, all right, you can throw this market value minus actual price formula out the window, and because I like my income for the whole history of the property, as long as this property has an effective lifetime, I can use that instead. That's not what the cases talk about. You've got a formula that is applied here. Profits can be worked in around those edges, but that's what that That's what those cases mean. And again, I would challenge you, look at the briefs. You will not see a case like this somewhere. You will not see a case where you've got a real estate contract.
That's true.
Thank goodness, we're not going to see another case like this, okay.
Right, and it is, thank goodness. But there's a reason for that. There's a reason for that because, and we're certainly, there's a reason for that because it's not the proper measure of damages. You are not going to see a real estate case where you've got properties not conveyed and someone goes off on this lost profits. I'm going to look for all of the profits I could have made from this property over the property's effective lifetime. The way you measure the damages is the way we've set forth in the briefs. They didn't do that here. And what you do with it, whether we remand or so, is within your discretion. But we would ask you to reverse and do something about this result here. With that, I will end.
Thank you, counsel. Thank both counsel for their presentations, or all counsel for their presentations, for that matter. We will take the matter under advisement and issue a decision in due course. We stand recessed for several minutes to allow the attorneys for the next case to come forward.